Welcome to This Explainer. Look, buying your first home in India is a massive, incredibly exciting milestone. But let's be real for a second. If you aren't prepared, it's basically a legal minefield. Today, we're taking the complex, honestly kind of intimidating world of Indian property law and turning it into a clear, no-nonsense survival guide designed specifically for you, the first-time buyer. Let's jump right in and confront a pretty harsh reality. You see, Indian courts consistently emphasize the absolute importance of documentary evidence. What does that mean for you? It means in the eyes of the law, a seller's verbal assurances, no matter how friendly they seem, mean literally nothing without the paperwork to back them up.
So I gotta ask, are you really willing to risk your life savings on a handshake instead of rock-solid legal proof? Falling for a verbal promise is hands down the biggest trap for first-time buyers in India. Stick with me in this explainer, and we're going to learn exactly how to protect your dream home from turning into a decade-long court battle.
Here's our roadmap for today. We'll look at the high stakes of property buying, break down ancestral versus self-acquired property, cover the essential documents you absolutely need for title verification, learn how to spot warning signs of fraud, and finally, figure out how to resolve encroachment and possession disputes. All right, let's dive right into Section 1, the high stakes of property buying. Why exactly are property disputes so incredibly common across India? Well, the vast majority of those agonizing legal battles begin for one very simple reason. A buyer trusted a seller's word instead of doing their own strict due diligence, relying on unverified ownership claims or, incomplete documentation. That almost always guarantees a disastrous outcome. It's like building a house on quicksand. Just imagine finally moving into your new home, only to get a legal notice from the seller's estranged brother claiming he owns half the land. Crazy, right? But as a buyer, you aren't just buying a plot of land. If you aren't super careful, you might be buying into hidden family feuds. The most common traps we see are inheritance disagreements, boundary and partition suits, fraudulent sale deeds, and illegal possession of the land. Which brings us perfectly to Section 2, Ancestral versus self-acquired property. The origin of the property literally changes the entire legal rulebook.
You absolutely must ask how the seller actually got the property in the first place. Ancestral property is passed down through generations, which means there are shared family rights involved. You can't just buy it from one guy. You need the green light from multiple legal heirs. On the flip side, self-acquired property is purchased independently with personal funds. That makes transferring it a whole lot more straightforward.
Depending on the seller's background, there are specific succession laws that dictate who truly has the legal right to sell that property to you. Key legal frameworks, like the Hindu Succession Act of 1956 and the Indian Succession Act of 1925, are specifically there to protect the inheritance rights of sons, daughters, spouses, and other legal heirs. A perfect example of this in action is the landmark case of Vanita Sharma versus Rakesh Sharma. This case established crystal clear rights for daughters in ancestral property disputes. So what's the takeaway for you? If you buy ancestral land without making absolutely sure the seller's sisters have formally relinquished their claims, they can legally challenge your purchase years down the line. Yikes. Okay, moving right along to the most critical phase of our explainer, Section 3, Essential Documents for Title Verification. If you only remember one single thing from this entire explainer, please let it be this. A properly registered sale deed is your absolute best shield against future court disputes. Under the Transfer of Property Act of 1882, this document is definitively the strongest legal proof of ownership you can possibly have. It's the gold standard. Now, let's clear up a massive, and I mean massive, legal misconception. Mutation. Mutation is really just an update in government revenue records for tax purposes. Paying property taxes through mutation records does not legally make you the owner. It simply does not confer title.
And guess what? Scammers absolutely love to exploit this exact confusion. A shady seller might confidently flash a mutation document as proof they own the land. Please don't fall for it. Mutation only proves who pays the tax bill to the government. Only the registered sale deed proves actual legal ownership. Never confuse the two, all right?
So here is your non-negotiable, step-by-step checklist to make sure the legal title is squeaky clean before you hand over a single rupee. Step 1, demand the original registered sale deed. Step 2, cross-check those government mutation records just to be extremely thorough. Step 3, verify identity documents to prevent any impersonation. And Step 4, confirm that the physical possession matches exactly what's on the paper.
Seriously, trying to take legal shortcuts is going to cost you everything. Take the landmark case of Suraj Lamp Industries versus State of Haryana. The Supreme Court actually invalidated property transfers that relied solely on a power of attorney. Buying a house through a power of attorney instead of a registered deed, yeah, that just will not hold up as a valid transfer of title in court.
And that brings us to Section 4, Warning Signs of Property Fraud. Let's see how taking those shortcuts plays right into the hands of scammers.
If you spot any of these red flags, you need to turn around and walk away immediately. Be extremely wary of sellers who flat out refuse to show you the original documents, or folks who rely on unregistered sale or gift deeds. Watch out for suspicious or forged identification, and definitely be on high alert for aggressively rushed sales using a power of attorney. These are massive warning signs for forgery or impersonation.
Now, you might be thinking, but wait, what if I bought it in good faith? Sadly, the legal consequences are still severe. Property purchased through fraud, impersonation, or forged documents can, and totally will, be challenged and invalidated by competent courts. You could very easily lose both the property and your hard-earned life savings.
All right, let's get into our final section, Section 5, Resolving Encroachment and Possession Disputes. This is all about actively defending your property once you've legally bought it.
Keep this critical distinction in mind. Physical possession, meaning someone is currently living on or using the land, does not automatically create legal ownership rights. Legal ownership comes solely from holding those registered title documents we talked about. This is super vital to know if someone ever tries to illegally occupy a vacant plot you just bought.
If you do face encroachment, whatever you do, don't take the law into your own hands. Instead, file a civil suit for recovery through the courts. You can utilize the protective provisions under the Specific Relief Act of 1963. Make sure to act quickly within the legal limitation period, and listen closely. Never, ever rely on verbal evictions. Always do it by the book and get it in writing.
As we start to wrap up, I just want to remind you that this explainer is strictly meant for educational purposes, because every single property's history is incredibly unique. Hiring a qualified advocate to conduct professional legal due diligence is hands down the smartest investment you can possibly make.
I want to leave you with this final, crucial thought. You've verified the seller, and you've toured the beautiful property. But is your legal paperwork truly court-proof? Before you even think about signing on the dotted line, ask yourself that question, and ensure your documentary evidence is completely flawless. Thanks so much for joining me on this explainer, and hey, happy